Hi everyone, my name is David Chu. I'm here to answer your legal questions, and today I'm answering the question about evictions and specifically what happens if you lose the eviction case. If you're a tenant and you went to court and the judge ruled in favor of the landlord, you're probably wondering what your options are. And there's pretty much only one option you can do now that you lost at the Justice of the Peace Court level, and that option is you have to appeal. And you have 5 days from the date of the judgment to appeal, and the date that you have to appeal is usually told to you by the judge. So before or at the time the judge issues a judgment in favor of the landlord, he'll also say, oh, by the way, if you wish to appeal, the last day to do so would be, and then that date happens to be 5 days after the hearing which you lost. So in order to appeal, you would need to post a bond, and that bond would be the amount that the judge specified at the hearing. So before you leave, maybe too late now, but of course, but before you left, the judge likely told you two things, and that's the last day to file the appeal and the amount of the bond. And most of the time, people can't really afford the bond because the bond would be the amount that's 2 times the amount of the judgment. And the judgment would likely be the court costs plus attorney's fees plus the amount of past due rent that you owed at the time the eviction court was heard or eviction case was heard. So if you can't post the bond in that amount, can't pay a cash bond, you go to a bonding company and only have to pay 10% of that bond. The other option in small claims court is if you have no money to even pay the bond, what you can do is you can get an ability to pay. It's an affidavit where you provide financial information and you tell the courts that you don't have money to post the bond, to pay a bond, you don't have money to pay a cash bond. And by doing so, the court, if they approve your affidavit, what they will do is they will waive the filing fees, and they will also waive that bond requirement. However, if you do get your case appealed to the county court level on a basis of the inability to pay affidavit, you have to remember that you do need to pay the month's rent or the amount of money per month for rent into the court registry. So if you appeal the case because of an inability to pay, then you have to still at least pay the rent money into the court registry. So at the time you file that inability to pay affidavit, be sure to get the details about how to pay the rent payments into the court registry. Because if you file an inability to pay affidavit, it gets approved, and you don't pay the money into the court registry, then what happens is that the landlord can ask for a writ of possession and get that property back. So the important thing to note is that if you lost your eviction case, you have 5 days to appeal. Be sure to do that before the 6th day, because if you don't appeal within 5 days, on the 6th day, then the landlord can go to court and ask for a writ of possession and take that property back from you without your ability to appeal the case or having it heard at the county court level. If you have any more questions, feel free to send me a message or contact me with the information below, and I'll be glad to answer them on this channel. Thank you so much.